Yes, Mr. Williams.
First of all, apologies, my Lord, for keeping the court waiting. It wasn't for want of trying to be very quick, but when we got back to chambers, we didn't have all the resources that we would ordinarily have due to pinging and...
You've been pinged, though?
Not me, but the chambers, two clerks are self-isolating, but that's not an excuse so much as a reason, so our apologies. And next, a clerk has just come in and given us only 4 copies of the note that you requested, although by the time we emailed it to Mr. Mould and Mr. Elvin, it was too late for them to have their own copies. So my suggestion, since it is only a document providing you with the summary references, which I hope is what your Lordship was asking, is that we can provide that to you, and quite happy if my own friends want to make what comments on it, that they will.
Yes. Have you got it then? So where are we now?
Yes, we've got four.
Mr. Mould still haven't seen it yet.
Well, I'm just trying to get it.
I lashed it on the optimistic about Wi-Fi in the building.
Yeah. I'm afraid I'm using my phone to get Wi-Fi.
Thank you.
Thank you very much. Well, well done for getting this all typed.
I'm very grateful to you, Miss Murphy, on this. We've done our best to try and target our answer to what we understood to be a Lordship's question, whilst also ensuring that what we put in was sensible and adequate.
Yeah. So Mr. Mould and Mr.
My Lord,
Elvin can add to this as they wish, I suppose, is the way to deal with it.
Thank you.
When we get there. Is that right?
All right, thank you. Right. Now, just before we carry on, how are things progressing?
I have I've almost finished ground 1C.
Yeah.
Ground 1D is a shorter point.
Right.
He says hopefully, and ground 2 is an even shorter point, since factual matters would have been covered. He says again hopefully, and ground 3 likewise is shorter. If you are asking for an estimate, I'm reluctant to give it.
No, I mean, I just wondered roughly where we were, and maybe you've answered it. So how, broadly speaking, how long do you think we might need now?
Half an hour?
Yeah. Fine.
I might live to regret that, but that's my rough estimate.
All right.
So we were still in ground 1C, which is the issue of EMRs and how the inspector dealt with them. And it was our submission that he had, in effect, done exactly what the Court of Appeal said should not be done, which is completely relying on the EMRs to do and take away from the statutory task that was given by Parliament to the local authority. And I had referred to the decision letter, and perhaps it might help if I just gave you the 4, 5, 6 paragraph references for your note. Paragraphs 20, 26, 65, 70 and 76. I would like to turn next to a couple of passages in the judgment. And I ask court to turn to paragraph 213 in the judgment, which is at page 102. And from that paragraph on to the next page, paragraph 218, there's some pretty important paragraphs about what the judge has taken from the decision letter. It's our submission that he's not considered the decision letter correctly, and in this particular regard, it relates to the approach taken in the decision letter to the EMRs. I won't read 213 and 214 because your Lordship's read that before lunch, but you recall the the penultimate sentence is 214. This was an evaluation for him, and then he says, and he didn't leave it to somebody else. He did. He actually left it to HS2 in the EMR process in express terms. It's not simply a matter, as the last sentence might be taken to mean, that he had regard to the EMRs, but not so as to take away what Parliament had given to the local authorities for their evaluation. It is that he looked to the EMRs instead, bearing in mind he had not himself evaluated paragraph 6. Now 215 is also relevant insofar as the learned judge says at the bottom it was not suggested that when the paragraph 6 factors were being considered they became irrelevant, which would have been an impossible approach. Well, that wasn't our submission. He then says the inspector didn't say that the conditions were wholly irrelevant because of the other arrangements. Actually, what he did, he said the conditions were not justified because of the other arrangements. And in 216, the learned judge says this is not hiving off or delegated functions in the way found unlawful in Hillingdon 1. That's where we have a stark disagreement with the learned judge. Here, although LBH may wish to have controls, it did not identify any specific controls, but instead sought a scheme under which it would approve and enforce controls. The inspector didn't hold that specific controls, if identified, which would resolve traffic problems which would otherwise interfere with free flow or road safety, could not be imposed. And then there's a long paragraph in which the learned judge makes a number of comments, many of which do not actually relate to the submissions that were made before him, but he's eliminating other points as he's going along. But about 7 lines down, he says, of course, the guidance does not have the force of law, and it cannot and did not strip away the powers of the local planning authority. Well, he's right to understand that that's the point, but he's wrong to say that the inspector's decision didn't, in essence, do just that. And then he says it was not so treated by the inspector here either in relation to his powers. Well, that's a matter for this court to determine, having regard to the terms of the decision letter. And then 218, there are 2 paragraphs that I want to draw to your attention where we believe the inspector has, by aligning himself with the inspector's decision...
The judge has.
The learned judge, I beg your pardon. By aligning himself with the inspector's reasoning, has fallen foul of exactly the same problem. And the first is at 218, where he says this: there's nothing odd, moreover, about a planning authority not having power to impose controls on the range of matters which it might, as planning authority, have to consider. And then he looks at Highway and Pollution Control Authority, for example. Pausing at that sentence, what is that intended to refer to? Unless it is a tacit acknowledgement that actually the power of the planning authority under Schedule 17 is being overlooked or bypassed. He seems to be saying, that's okay. Fine, you may have that control, but if one can look to other arrangements, then it doesn't matter that you don't have control. Now that flies in the face of the Court of Appeal's rationale, which is to ensure the authority has the ability to determine and evaluate the need for, in short, litigation. further point in that paragraph is equally erroneous, we say with respect, and that's the penultimate sentence on the page. The nature of the applicant and other controls over it may rationally be treated as sufficient assurance. What he's saying is it's rational for the inspector to have regard to the nature of the applicant and the other controls, but what he doesn't grapple with is what the Court of Appeal said in Hillingdon, which was actually the applicant's identity is important. It's not a question of the other controls being some independent body. This is where the so-called other controls are led by HS2, which flies in the face of a principle about judge and cause, paragraph 82 of the Court of Appeal's judgment. There's a further paragraph that Lordships may wish to take into account in that context. I think that's not the case. That was the end paragraph I wanted to refer to in that. So that deals with ground 1C.
Right.
Ground 1D, set out in full, is really targeted at two passages in the decision letter, paragraphs 46 and 70.
46 and 70.
And in short, we say that the inspector misunderstood Parliament's intention in establishing the Schedule 17 process. He wrongly proceeded on the basis that any effects below those assessed in the environmental statement at the bill approval stage must be acceptable. And such an approach, we say, misconstrues Schedule 17 as offering, in effect, no meaningful control mechanism. So, looking first at 46, he says, the inspector, it's also important to note that the outcome of the Select Committee's examination, including its consideration of the evidence submitted by the Council and the adverse impacts on construction traffic, was that the Act was passed and deemed planning permission was granted. Although Parliament no doubt had regard to the EMRs and various undertakings and agreements given by HS2, the Act does not set specific limits on flows. It must therefore be assumed that Parliament concluded that the assessed impacts were acceptable, notwithstanding its expectation that additional work would be undertaken to try to further reduce those impacts. That, in my submission, falls far short of the understanding given by this court in Hillingdon 1 to what the Act does and the important process set down by the deemed permission provision and the Schedule 17. You'll remember that the Court of Appeal was explicit in ensuring that it was understood that Parliament had, because of their democratic accountability, sufficient powers to control certain matters through mitigation, through paragraph 6.
Do you want to identify those paragraphs in the Court of Appeal judgment,
Yeah.
which you say is?
Yeah.
Do you turn them up, just for note my notes?
Yes, 68 and 72 to 73 are particularly relevant.
68, 72, 73. Thank you.
In relation to paragraph 46 of the decision letter, the inspector indicates clearly that he misunderstood by saying the Act doesn't set specific limits. Whilst factually that's true, it doesn't take into account Parliament's intention, expressed by the Court of Appeal, that the whole purpose was to, as it were, devolve power to local planning authorities is to consider the question of, in broad terms, mitigation. The reference to it must therefore be assumed that Parliament concluded that the assessed impacts were acceptable. This too seems to ignore the clear intention of Parliament. Acceptability, according to Parliament's scheme in the Act, could only be determined at the Schedule 17 stage. And the use of the word try doesn't really reflect the intention of Schedule 17 as explained by the inspector. It seems to suggest, well, it's fine so long as there's some attempt by HS2 to reduce the impacts. It seems to bypass, overlook the whole purpose of Schedule 17 to impose a control system to find mitigation where it's evaluated properly. The learned judge deals with this point in particular at paragraph 209. Sorry, 2109, I beg your pardon, my lord.
219.
219. It's the next paragraph after the one we were just looking at. 6, the significance of the bill, and it refers to the point we took on the decision letter about the significance of the enactment of the bill. And halfway down, the learned judge says this: as I've said, this is not an irrational conclusion on the material which the inspector had. Well, just pausing there, this is not a question actually about irrationality. We weren't saying to the learned judge that the inspector's view on this point was irrational, except for in the context of parliamentary intention. What we were saying was that the inspector wrongly understood the parliamentary process. And then he says this: but the inspector did not use that conclusion in a way which was objectionable as a result. He treated it as material to how he should approach the justification for further controls. It's relevant to that, but it was by no means as important as his evaluation of the evidence of prejudice or other forms of control. He didn't say there was no need for controls to ensure that the levels were kept to those in the submission. The first point is that the phrase that the learned judge puts in quotes in the middle of the paragraph, notwithstanding, is actually not the important bit of the paragraph. The learned judge has emphasised the bit that actually isn't the real target of our complaint. The whole of paragraph 46 must be read. The second point is that the judge seems to accept that what the inspector said actually had a material effect on his approach. And that's our concern. And then the judge seeks to excuse, with great respect, the inspector by saying that it had relatively less importance than his own evaluation of prejudice. I've dealt with that evaluation point. Insofar as it had a material impact on the decision, it was wrong, and it misled the inspector, and the judge similarly seems to have gone awry. The other paragraph that I wanted to refer to in this context is paragraph 184 of the judgment.
Are you going to come back to 220?
Or not bother with that?
No, I think that's a sort of more of an overall conclusion, and I'm hoping just to deal with this specific point. So paragraph 184, in the middle of that paragraph, the learned judge says this: there was an issue about how the passing of the Act and the grant of permission should be taken in assessing the need for further controls, but that's a reasonable approach for the inspector to take. As the inspector reasonably found in paragraph 70, Hillingdon was seeking to renegotiate that agreed position by introducing new and additional controls requiring peak time numbers to be limited, and that amounted to a modification of controls within the EMRs. That was their purpose after all. The same applied to the requirement for recording and reporting peak time movements on a weekly basis. Now, insofar as this is an expression of view by the learned judge, that too seems to align itself with the inspector's erroneous view that levels of impact that had been considered at the bill stage were in some way or another to be regarded as acceptable, and anything else, where it was addressed in the EMRs in whatever way, was not really a matter for Schedule 17. That's all on ground 1D. Ground 2, I think in large part, my Lord, we're content to rely on the Commission skeleton argument, page 23. In short, we say that the inspector failed to take account of considerations material to the statutory task.
Sorry, do you want us to look at this?
I think only to have it to hand.
Yeah, okay.
Just trying to summarise the points of page 23.
Yep. That's bundle page 23. Yep.
39, thank you.
Bundle page, sorry, in channel 23.
Bundle 39,
Yeah,
document 23.
got it.
Yeah. And here we say the inspector failed to take into account material considerations necessary for his task. And we have two broad submissions here. The first is this, that although based upon the same facts, the legal framework differs in relation to this ground of claim from those referred to in ground 1. But what we say is that the inspector's decision failed to identify and reach conclusions as to the impact on the proposals and the interests within paragraph 6. Those being related to the free flow of traffic and road safety. And we say that using that different framework of analysis, governed of course by Friends of the Earth case and the Sam Smith, these were considerations which were expressly or impliedly identified in the Act. Free flow and safety obviously is, and there was no express or clear findings on what the nature and level of the traffic impact was, for the reasons we've given. And in particular, implied into the statute by reference to safety and free flow, peak hour movements are particularly important and relevant. Baseline flows are particularly important and relevant. And the impacts of the two combined are particularly important. But as I've indicated or sought to persuade the court, the inspector actually, because of his erroneous approach in various respects, didn't really grapple with those issues at all. He didn't make his own findings. Mr. Mould argues in his skeleton argument that it's perfectly all right because he drew reasonable factual inferences. But actually, if you look at the decision letter, it's a question I posed already, and ask yourself the question, well, what did the inspector conclude clearly in relation to the lorry movements, the baseline flows, the impacts? He didn't. He didn't actually carry out that task. What he did was say to the authority, it's your task to do this, as opposed to a legal burden. You haven't matched it. I'm not going to actually look at it myself because that's the only legal test I have to satisfy. So that's ground 2. Ground 3, similarly, my Lord, essentially to rely on the permission skeleton at page 24. This is again another legal framework for analysis, because unlike This is different from ground 1B, our argument deriving from the statutory principles established in Hillingdon 1 Court of Appeal. Here, we're dealing with the case on the basis that the judge was right to deal with on an irrationality basis. And it's clear that he did so approach it, but we say that such information as was before the inspector dealing with impacts did suggest that some harm would or might arise, that's reference to environmental statement and TFL, and there was no other substantive evidence on the specific arrangements proposed, for reasons I've already set out. The inspector found that against the council, however, not because he himself considered those issues by reference to sufficient evidence, but solely as a result of the evidential threshold he set, and he made no specific or clear findings of the relevant questions within paragraph 6. I think the only additional point to make, and as set out in paragraph 43 of our skeleton argument, is that one mustn't forget that there are two aspects to irrationality. The first is to look at the decision letter on the basis of a range of reasonable conclusions that the inspector may have come to. And a judge might say, well, it's perfectly rational for an inspector to form conclusion X because it's within a range of reasonable conclusions. That, we say, is what the judge did here, but it's a less exacting standard than the other aspect of irrationality, which is where the court asks, was there evidence to support an important step in the reasoning of the inspector? And we say that that part of the irrationality test should be more exacting than that which has been carried out by the judge. In any event, what we say is that whichever route is chosen by this court, and the matter is analysed fairly and correctly in the context of adequacy, for the purposes of carrying out the statutory duty, it doesn't matter, the answer will be the same. Those are my submissions, unless I can help the Lords at 10 o'clock.
No, thank you.
Thank you.
Thank you very much, Mr. Howells. Thank you. Yes, Mr. Mould. Well, just before you make any submissions, I think we might just rise for a short time to consider what we want to do. Thank you.
I think you can probably assume actually that by the time you create that I won't know to add, because in a sense your my knowledge of
I'm a master.
but also you were both in the fray, weren't you? Whereas I was I suppose you might say a decision maker ought to know what documents they have. There's plenty of document list, is there?
No.
Which is rather odd. I find that paradoxically much more difficult. You're geared out to a logic.
Yes, Mr. Mould.
My Lord, I know that Mr. Elvin is just having a look at the evidence list that Mr. Hull-Williams and Miss Murphy prepared over short adjournment. But in the meantime, the court may well have noticed pages 273 and 274 in the core bundle, which is the conventional list of documents that is appended by an inspector to a planning appeal decision.
Oh, yes.
And in this case, the inspector has very helpfully divided his list amongst the documents that he received from HS2 as the appellant, and also on page 274, the documents that were appended to the council's submission. So when you receive the list or the note that the parties are preparing at the moment, you may want to correlate that to that list, because that's the official record of the documentation that was before the inspector.
Yeah, thank you very much. All right.
My Lord, if I may, I'm going to begin by just touching on a couple of aspects of the statutory scheme.
Yes.
Not knowing, of course, that this court looked at that in some detail last year, but I take my cue from paragraph 4 of my skeleton argument, where I refer to paragraph 13 of Schedule 17 to the Act. You have that in the authorities file. And that is the paragraph which effectively is, one might say, the reason why we're here, because it was by virtue of Hillingdon as local authority having given undertakings to the Secretary of State that they were able to assume the broader functions of a qualifying authority under the planning schedule, which include, of course, for the present purposes, the right to make decisions about lorry routing arrangements under paragraph 6. If it wasn't for the fact that they had given the undertakings, which I'll come in a moment, there would be no question of Hillingdon making decisions about arrangements for lorry routing, because they would not; those powers would not be vested in them. And of course, the reason I put it that way is because there's a quid pro quo. In order to enable Hillingdon to exercise those broader powers of decision-making and control under paragraph 6, they have to say that they will abide by the undertakings that they have given to the Secretary of State under the aegis of paragraph 13. And it is part of the constitutional arrangement, to use a phrase that I think this court used last year, just as much a part of the constitutional arrangements which govern local authority decision-making under this planning schedule, that those powers should be exercised in accordance with the undertakings given. And the reason for that is that those undertakings are designed to ensure that the overarching public interest in the efficient and timely delivery of HS2 should not be undermined by delays or difficulties in local authority planning decision-making in the exercise of the powers under the planning schedule. That overarching legislative intent is one, of course, that was at the root of this court's decision last year. It emphasised the importance of collaboration, emphasised the importance of reasonable behaviour, and whereas in that case, to use the verb used by this court, the effect of the Secretary of State's decision on the facts of that case, extreme as they were, was to abrogate control from the local authority to HS2 as nominal undertaker. The court should be equally astute to avoid the converse, which is a local authority seeking to abrogate controls, management, such as traffic management, which, under the constitutional arrangements which they have signed up to as qualifying authority, are vested in the environmental minimum requirements and are dealt with by the nominated undertaker and its contractors, under, of course, the tutelage and control of the Secretary of State, who is answerable to Parliament for compliance with the.
So that's how you address the democratic accountability.
Quite. There is no necessary deficit here, and the short answer to the argument on appeal that conditional controls were necessary in this case for the reason to control peak hour movements and to control the safe operation of accesses. Those are the two aspects to which the proposed conditions were focused as a matter of substance. The short answer is that each of those matters was vouchsafed essentially to be dealt with under the traffic management arrangements in the Code of Construction Practice and the local traffic management plans. And to suggest that being the settled arrangement contemplated by the essentially under paragraph 13, because that is the root of this, but to suggest that is somehow abrogating control, democratic decision making from the local authority is to misunderstand fundamentally Parliament's intention, which is that qualifying authorities should have those wider powers on the explicit understanding that they fulfilled the undertakings that they had signed up to and the Secretary of State had required of them.
But don't you then need to show us the undertakings?
I'm going to show you them straight
right,
away.
okay, yeah.
I'm
not saying
setting out
what you're saying is
the
wrong, but I'd just like to double check,
Yeah.
I'm afraid.
So the undertaking is set out in the planning memorandum,
Oh, right.
which I hope was one of the documents that you may have had a chance to look at. I sent a list around yesterday.
Yes.
May not have been, but it's in the it's in the supplementary bundle at tab 10. Now this is a document that this is one of the core documents of the environmental minimum requirements. This memorandum, and it was in draft form before Parliament when the bill was passing through its parliamentary stages. So it was before the Select Committee in the House of Commons, before the Select Committee in the House of Lords, and it is this document that sets out the undertakings that qualifying authorities have signed up to in order to be designated in the relevant statutory instrument by the Secretary of State. And one sees that, one sees the page which they sign at page 179. The heading is qualifying authorities. Reference is made to paragraph 13 of the schedule and to the Secretary of State's power to specify. Then 2.1.2, this memorandum sets out those undertakings. It's binding on upon an authority which is scheduled to sign it so as to have the additional powers available to authorities under the bill and upon the nominated undertaker, and it shall be taken into account in determining matters submitted for approval to qualifying authorities under Schedule 17. And then you see that a line is allowed for the signature, and the authority. There is somewhere in the files of the Department of Transport, no doubt, there is a document which bears Hillingdon's seal or the signature of the Chief Executive. Hereby undertakes to act in accordance with the terms of this memorandum.
So, when was it? Do you know that Hillingdon signed this?
It would have been either on or shortly after the date of royal assent, which was February 2017. I don't recall precisely, but the order designating, I think, if I remember rightly, either all or almost all of the local authorities through whose administrative area the London to West Midlands Railway runs. That order was made by the Secretary of State in February 2017. If you'd like a copy of the order, I'm sure we can make one available to you. It was a statutory.
No, I mean, I think it's enough for us to know that it was signed on or shortly after royal assent in February 17.
If I may, draw attention to to the following passages, the following paragraphs in this document. Firstly, section 4 on page 180.
Does 3 and 3 help as to understand what it's about? Because we've said it, but it's been glossed over. The starting point is the bill has given planning permission, as I understand it,
Yes.
for this. And the approvals are a bit like, although I know you're telling me I mustn't use this language, approval of reserved matters, isn't it?
Well, there is a broad analogy there, and certainly one of the just to illustrate the point here on the facts of this case, we know that Hillingdon has not suggested throughout the consideration of this application for approval that there are any alternative routes which HS2 should follow in substitution. So in order for the railway, we know that these work sites, 5 or 6 of them in number, which were the subject matter of this compendious application for approval, are absolutely central to the construction of HS2 within the area of West London and out into the Colne Valley.
Well, they've got planning permission for the works. There's no dispute now about the roads that are going to be used to take the materials to and for during construction, presumably. Yes. And then what we're talking about is matters in respect of the use of the road, the arrangements in narrow terms at peak time, and also the question of access.
And the purpose of my submission is to emphasise the narrowness of the inquiry, because it would clearly not have been open to Hillingdon or to the inspector to have refused to allow these roads to be used.
Well, they couldn't say we don't want roads to be used for a construction site because there's planning permission for that.
Exactly. And it would be tantamount to withdrawing the authority that permission gives. So they were necessarily limited to considering matters of detail. And so although Mr. Hal Williams says this wasn't just about whether the conditions were necessary, in practice, that is where one is driven by virtue of those very points. It is a question as to whether there's a need for, on the one hand, some additional peak time controls or some form of additional monitoring arrangement, or whether there is a need for further site-specific controls in order to improve the safe operation of site access. And that then leads to a further point, which is complete contrast to the situation in Hillingdon 1, which is those are the sort of things that local authorities are perfectly well placed to deal with on the basis of their own knowledge. I mean, one of the things you may have been struck by the very fairly detailed explanation in the written statement of the actual routes to which each of these 5 or 6 routes follow, was effectively they take you on a walking tour through them or a driving tour. They tell you how to get from Thwaitley's roundabout in the A40 to each respective site. Well, the local authority highways engineer, one wonders why it was that person couldn't simply drive along that route, identify the location of the proposed access, and make a judgment about whether something more was required than was actually proposed in that document by way of safety arrangements such as improving visibility space. What was so difficult about saying this access isn't good enough? It needs to be managed. It needs to have a banksman. It needs to have an improved visibility display. The access point itself, the gate needs to be widened, or whatever it may be. And what was so difficult about saying this particular road is particularly congested at peak times? We know this for a fact because it's something which is a source of continuous complaint from our local residents. There's a school along that road which is obviously busy and creates a potential risk if one at the times of day when children are going into and out of school. We suggest, our case is that there should be a specific control on peak time movements in Malaysia. That's the kind of thing that one might have expected a local authority to have been very well placed to deal with.
It's not a generic control about road and safety matters as you would have if you were deciding whether or not to grant planning permission. Its permission's been granted, the roads have been approved, that carries with it what will be necessary for the construction works, but there may be specific problems rather than generic problems. Is that what you're saying?
And, exactly, and one sees an example of that kind of focused decision making being played out, actually noticed, relied upon by the inspector in this decision. Can I just show you that, just to illustrate this?
Are we putting the...
Do you mind just putting it to one side? Because
Right.
I want to show you...
The undertakings.
Yeah.
we were going to look at those.
But as we've
Decision letter, yeah?
gone down this road, forgive me, if one turns to the decision letter itself, dealing with proposed condition 2, which begins at the inspector's analysis begins at page 269 in the core bundle. You see that one of the criticisms that he makes of the council's case for additional controls in relation to safe operation is at paragraph 81 on page 270. Having carefully considered the council's submissions, my conclusion is that overall they constitute general assertions about the nature and sensitivity of certain parts of the network. They don't, however, serve to demonstrate that the movement of LGVs to and from work sites would, as opposed to might, have a prejudicial effect on the free flow of traffic or highway safety. And then he contrasts that with the situation in relation to another appeal, which he discusses at 83. In Appeal Ref HS2/2, the Inspector and the Secretary of State accepted the need for condition to place a restriction on LDVs making a right turn out of a specific work site. That condition differed from proposed condition 2 in this case, in that it introduced a clear and specific modification to the application submission. There was also full agreement between the appellant and the council that clear evidence existed as to the need for that restriction on highway safety grounds, and that the arrangements for the proposed lorry routes ought to be modified in that way. As noted by the appellant in paragraph 4.25 of their response to the council statement, the need for a right turn back had been contemplated in the LTNB, but did not expressly require such a restriction. So where there was a clear and specific case evidenced by the local knowledge and experience of the Highway Authority for a control of that kind, Secretary of State and the nominator, I think, are perfectly ready to agree to it. But in this case, Hillingdon hadn't done what one might have thought they might reasonably seek to do, which was to examine the proposed access points, 5 or 6 proposed access points, and say, well, what more needs to be done here? And if nothing more needs to be done, then we don't need to make a point about it. But if we do need to do, if we think more needs to be done, we need to descend to specifics.
Yeah.
Now, in the case of in Hillingdon 1, the task of Hillingdon was to consider whether earthworks, in order to create a nature conservation mitigation site, a pond for newts, and so forth, whether earthworks would harm an archaeological asset or archaeological remains. Everybody knew that the site in question might well have items of archaeological value within it.
Yeah.
But nobody knew whether it did. And the only way one could find out was to investigate it by digging, effectively. One had to carry out a survey in order to do so. And because HS2 said of access difficulties, they hadn't been able to get on and do that by the time that the approval process did. So, in that case, the very subject matter of the council's evaluative judgment, that is to say, the potential or actual archaeological value in the site which was supposed to be disturbed with the earthworks, was completely unknown. And that was what, as I understood it, my respectful submission, it was that which was the gravamen of the court's concern.
Yeah.
That absence of any information of value.
Coupled with the fact the way that was going to be dealt with would be leaving it to the undertaker to sort it out itself,
Yes.
rather than
Yes.
through any other mechanism.
That was the abrogation.
Yes, but
Yes.
the
Yeah.
judgment seems to treat both together. You need the information because what was proposed as an application, everybody accepted.
Yes.
This might have an effect, and there might be a specific tailoring you could make, but nobody knew if it did have that effect.
Yes, yes.
I mean,
And
I was going to say, I'm going to detach ourselves from the facts of both this case and the last Hillingdon case. But there may be circumstances in which it is possible to say, on the facts, that the request for approval that is made doesn't constitute a meaningful request at all.
yes,
That may be a very extreme band of cases.
yes,
I'm not allying that proposition necessarily to the facts of Hillingdon 1, but there may be circumstances in which, in truth, on the facts, the request, so called, is not a meaningful request at all.
yes. Another way of putting it in public law terms is to say any reasonable authority who receives an application for which requires them to make an evaluated decision on the basis of information that is essential to that evaluated decision, and who any reasonable authority will recognise immediately that they are unable to make that decision unless they perform their Tameside duty. They will recognise that they need to inform themselves of that essential information before they can make a lawful decision. And this court's judgment last year can be analysed in that way, because this court essentially endorsed Hillingdon's position in taking what was broadly that course.
Yeah, yeah. I mean, there's a gradation, maybe. I've perhaps stated or attempted to state one end of the spectrum or range, and it may be or may not. We're not deliberating again on Hillingdon 1 today. It may be that Hillingdon 1 fell, if you like, an inch or two just to one side, within the range from that extreme case. It may or may not. That matters not now. Because one can envisage perhaps a range of factual circumstances in which that proposition you've just articulated could be applied.
Yes. I mention it because in my submission it is actually, it represents the legal standard, if you will, that Mr. Howe-Williams was looking for when he was seeking to answer my Lord's questions earlier about, well, what is the legal test? In public law terms, given that we're firmly in the field of public law decision making,
Sure.
in public law terms, if a decision maker declines to make a decision or refuses to determine an application that they're required to determine under a statutory scheme on its merits, because they say they lack the essential information on which to do so, they can expect the administrative court to vindicate that approach on a challenge to that, on the basis that they were fulfilling their Tameside duty.
Yeah.
But of course, the question whether a decision maker has or has not fulfilled their Tameside duty is a question that is resolved on Wednesbury principles. It's an aspect of Wednesbury. And so it is in the first instance for the decision maker to decide in their own judgment whether they have or lack the essential information that they need lawfully to fulfill their decision-making function in whatever administrative field they are involved. And this court will only intervene if it is persuaded on the evidence that was before the decision-making or the lack of it, having regard to the statutory scheme which they were enjoined to give effect to, that they acted in a way that was unreasonable on Wednesbury grounds. There's no hard-edged issue of law, the way that my learned friend put it. And indeed, it's telling that he wasn't able to explain. His submission was question-based in that respect. He set up the question. He was asked the question, but he wasn't able to give it. I suggest that the answer to the question is the one I've given. And indeed, that is consistent with this court's analysis in paragraph 77. And indeed, on that point, consistent with the approach of the judge at first instance in paragraph 60, which this court identified, noticed in paragraph 64 of its judgment.
So you say to us, do you, that the ratio of, if I can use that expression, the basis for the decision in Hillingdon 1 is to be discerned essentially in paragraphs 77 and 78. 76, 77, is it?
It's 70, in relation to the duty to furnish adequate information, 77, 78.
Yeah.
76 is the court's, is the ratio in relation to the fact that the duty to evaluate, under in that case paragraph 3 of the schedule, was one that the authority had to carry out itself.
Yeah.
Rather than could not be forced to delegate it to another party.
Yes, and that in paragraph 70 in particular, including the final sentence of that paragraph, the observations made by the court are on strict analysis obiter.
Yes. The approach there set out, I would respectfully submit. Firstly, it wasn't necessary to the court's decision in that case, and so on that basis, obiter. But secondly, it's not necessary in order to give effect to the statutory scheme, because if I'm right in the submission I've just made to the court, then the authority in any given case can always say, we lack essential information, and if we proceed to a decision without that information, we are confident that we will be in breach of our duty, our Thameside duty.
In one sense.
And I'm so sorry.
One sense, looking at paragraph 77 again, Hillingdon 1 just doesn't address the problem here, because it says they've got to have information adequate to perform the task it's got to do. But it goes on at the end, it's important to note the common ground that in this case, HS2 Ltd did not provide such information. And the whole question here is whether or not they have provided such information.
Yes.
And for that, I do think you need perhaps to go back one step further and say, what is the task? Is it to decide generically, is it a good idea to have peak time movements or not? Or is it to do what you are saying you should do, which is start off with permission, accept that the roads are approved, and then whether there is a specific rather than a generic concern which justifies them moving away from those arrangements.
I've suggested that the specific, particularly by reference to the question of safe access,
Yeah.
which is really the subject matter of Condition 2. I've suggested that one would expect ordinarily that that element of local control that is Parliament clearly intended should vest in local authorities would be best achieved in practice by looking at specifics rather than...
They've approved the roads, they know where they're coming from.
Yeah.
You can see whether it's a blind turn, you say, or whether there's too many hydrangeas.
Yeah.
What about the number? Well, whatever it is, it's called
Or as the case may be,
Yes.
Sorry.
substitute it, other flowers are available.
Well, it's hydrangeas in July normally. Would it end in May?
Not sure how many flowers in general there are along Harville Road.
But what about the numbers about road traffic movement? So.
But anyway, be that as it may, one thing that I do not, that I cannot gainsay, at least not reasonably, is that I did not suggest below that local controls, if you like, on peak time movements fell outside the scope of paragraph 6. And the judge records
was a primary school right next door. I don't know whether there is, right next door. And they've got hydrangeas on one side and children on the other.
Yeah.
You might want to cut the hydrangeas. And you might want to say, but please don't have heavy goods vehicles running over the children.
Yes, exactly.
They go to school.
That is exactly a
Do you think that's
paradigm
what they should be
example
doing?
where, in principle, one can imagine that the arrangements might justifiably be modified in order to, by imposing a control on the movement of heavy vehicles along.
But it's not enough to say there will be heavy goods movements, and that's undesirable, because is inherent in the fact that there's planning permission and those roads are going to be used.
Yes, but my submission wasn't intended to close off any possibility of...
There needs to be a reason.
Yes, it's a question for judgment on the basis of the information and the evidence that is before...
Because the test is whether you ought to modify the arrangements, not what arrangements would be ideal, but is there a reason
Yes.
that makes you ought to want to modify? Okay, yeah, I've got it now.
And it's, I mean, self-evident. There is plenty of room for the local authority strongly to take the view that in that case there should be specific arrangements. For the nominated undertaker to say we don't agree because we're confident that our own traffic management measures in the local traffic management plan will achieve a safe operation. And to take the matter to an appeal, and for the inspector to say, I'm satisfied, looking at the arrangements that are proposed under the local traffic management plan, that the nominated undertaker should carry the day here. There's no legal issue involved there. It's just a standard issue of planning judgment. And that's essentially what happened in this case under condition 1. The inspector said, I've looked at the various relevant elements of the environmental minimum requirements, the code of construction practice. I've looked at the route-wide traffic management plan, the vehicle management system that is going to be in place. I've looked at the local traffic management plan. I've looked at the Hillingdon agreement. I'm satisfied that there's no need for anything over and above that, the arrangements which are set out in those documents. Knowing as I do, and I'm assuming as I will, that those arrangements will be complied with. HS2 won't go around breaching the requirements of the MRs. I'm going to assume that they'll seek to fulfil them. And I know that if they don't, and there's a fuss made about it, the Secretary of State will step in and require them to take the necessary steps to remedy the situation. Now, none of that analysis is in any way in conflict with the rationale of this court in Hillingdon. Essentially, for the reason my Lord puts to me, the question didn't arise. I mean, the vice of the Secretaries of State in the Hillingdon law was to say it doesn't matter that the local authority in this case simply isn't in a position to make any sort of meaningful decision, because the matter will be addressed by the nominated undertaker. And so they deprived, on this court's analysis, they deprived the local authority of any opportunity to fulfil its role. But in this case, the local authority has positively sought to fulfil its role. It has put forward an extensive case, relying on the environmental statement, relying on the predicted traffic movements, the 480 that were put forward in the written statement, and other matters, to say there ought to be a local scheme of control on peak hour movements. The inspector said, well, you may very well say that. I don't agree. I think that's a matter which is provided for satisfactorily through the local traffic management plan management measures and other matters, which bind the nominated undertaker as contractors, and I think that there's no justification for any more. And anybody who's been involved in planning decision making in the development control context will be familiar with that kind of analysis in relation to whether conditions should be imposed on granted planning. It is commonplace at planning inquiries for the local authority to say, we want to see conditions controlling this, that and the other, and for the developer to say, those conditions are not necessary because they will be addressed satisfactorily by other regimes of control, by pollution control or by the highway authority. Or we've set up and have agreed under the planning obligations that are before the inspector, agreed to establish a lorry routing plan whilst we're constructing this industrial estate, on which we will consult the local authority, and so on and so forth. Those are all bread and butter matters in planning. and they reflect the guidance of the Secretary of State.
And the challenge to such a decision, not this case, but the challenge to such a decision would be on classic public law grounds.
As the judge said.
As the judge said. If, for example, the inspector had missed something obvious and relevant, that would be failure to have regard to a material consideration, and his decision making on that particular condition or the need for it would be vulnerable to that challenge.
Yes.
Short of irrationality, I suppose. Irrationality too would operate.
Yes.
But that's, as you submit to us, that's a commonplace of inquiries into planning appeals.
And we know that this court and the administrative court on a number of occasions, certainly over the course of my time in practice, has had to grapple with the degree to which other systems of control are material to planning decisions. Gateshead is an obvious example of that. And the logic of the law in relation to the materiality of other systems of control is obviously that in an appropriate case on the evidence, the existence and operation of another system of control can be determinative. It is something to which the decision maker, the planning decision maker, can give determinative weight because they're satisfied that it resolves the concern that has been urged upon them satisfactorily.
I mean, more generally, leaving aside other regimes of control, the question is whether one of the questions is whether the condition is necessary, and that too is open to challenge on, but only on, classic public law grounds.
Yes. Yeah.
I'm not. The inspector might formulate it in terms of being not convinced that a restriction on opening hours for this A3 outlet is justified.
Yeah.
So.
And pick up another point to put against us. In practice, in resolving an issue of that kind, the inspector will principally focus on the asserted evidential case and submissions in support of imposing that control, imposing that condition. In other words, the asserted need for it. And if they're unpersuaded that the evidence that is brought forward in support of the asserted need for it and the submissions that are made in support of the condition, it's perfectly legitimate for them to say, I haven't been convinced.
But what about the separate point here is, Mr. Howard Williams says it went beyond that. It wasn't, he submits, wasn't convinced. It was that he'd set up a higher burden or threshold test. The local authority must do the following.
Well, that was the discussion about paragraphs 34 and 35.
It's a separate point, I know.
Yes. My submission is that certainly, in the light of this court's decision in England, the same inspector writing the same decision would clearly not express himself in those terms. But I don't accept that there was any substantive error, essentially for the reasons that the judge has given, because he does actually, although he expresses his approach in the language that Mr. Howell Williams took you to earlier, when you get to the substance of his evaluation of the case for either of the conditions, it is clear that he is evaluating the evidence for himself. If you look, for example, at I haven't forgotten the fact that I'm taking you to the undertakings, and I will come back to
We're leading you astray.
No, I'm sorry.
No, not at all.
My fault.
But if you look, for example, at the decision letter again, in the core bundle, 266, he introduces his discussion of the case for and against proposed condition 1 by posing the question whether the council has produced sufficient evidence to demonstrate the need for the conditions and whether the proposed conditions are appropriate. And if you look at the approach that he, how he concludes the discussion in relation to condition 1, at paragraph 77, page 269. He tests for acceptability of the conditions set out in paragraph 55. Now that is the culmination of his own evaluation of the material.
What do you say about the burden of proof point? Do you say that's, on your analysis, that's a side issue?
I say it's not material
To what
to the substance of
the way the statute works.
Yes, and that was plainly the view of a very experienced judge in this field, yes. And I respectfully adopt the judge's rationale in relation to that.
Well, do you acknowledge that it was an error, or do you say it wasn't an error?
It was.
Or
well, that wasn't the judge's approach.
No.
And I say that the judge was right to treat it as not being an error, because whether something is erroneous turns on among other things on the materiality of whether the degree to which it has materially infected the decision in question.
It would be material in Hillingdon 1 because there was nothing else. It would only be material here if Mr. Howell Williams is right that there should have been the production of the baseline and hourly movements rate. If he's right on that, then it would be material, wouldn't it?
Yes, it certainly. If there was if Mr. Howell Williams is right that there was essential information in this case, that is to say, information that was necessary in order for the council to fulfil its Tameside duty, which was simply lacking, so that the inspector fell into the error of concluding that he had sufficient information, amongst other things by virtue of applying the burden of proof, then that would be a material factor. But my submission is that the judge was right in concluding that the information that was before the inspector, whatever view you take about whether it might have been supplemented, and that's not the issue before this court. If, as I submit, gives the case, the judge was right in saying that on any view, the information that was provided to the council in the written statement and the route safety plan, and the information that was relied upon by the council in making its case on appeal, that taken together plainly amounts to legally adequate information on which the inspector was able to base his judgment as to whether there was a case, not a case, for the imposition of conditions. Then it is immaterial. And I mean, to a large degree, it's a side issue, because, as we've seen, the inspector, as you will have seen from your reading of paragraphs 59 through essentially to the end of the decision making, the inspector's analysis of the case for imposing conditions was primarily founded on his view that the conditions that were sought were unnecessary, because the matters that they sought to control, be it peak hour flows, monitoring arrangements, safe and free movement of vehicles, were all matters that were addressed and would be managed effectively through the operation of the traffic management plans and the code of construction practice, which is a convenient point, if I may, to come back to the undertaking.
yes.
On that point, it actually is convenient to draw your attention to page 186 in the supplementary bundle and to section 9 of the planning memorandum, where one sees two obviously relevant undertakings to the circumstances of the present case. Firstly, 9.1.1 under the heading Environmental Statement in EMR. In determining requests for approval, the qualifying authority shall take into account the assessments in the environmental statement, the arrangements in the Code of Construction Practice, the Heritage Memorandum, the Environmental Memorandum, and any relevant undertakings and assurances concerning the project specified in the Register of Undertakings and Assurances. Now, the traffic management plans are amongst the arrangements in the Code of Construction Practice. So the undertaking, Hillingdon's undertaking, in order to have the powers vested in it under paragraph 6 of Schedule 17 of qualifying authority, was it exercising those powers, it will take into account the arrangements in the COCP. And then over the page, 9.3.1, the qualifying authority must have regard to statutory guidance issued by the Secretary of State in accordance with paragraph 26 of Schedule 17 of the Bill. Now, it might be thought that that adds little to paragraph 26 itself, but it certainly reinforces the point that in obtaining these wider powers of local control, the qualifying authority has positively undertaken to have regard to that guidance, which I'll come to in a moment. So those are those two. Now, obviously, the undertaking is given by the local authority. It's not one that binds the inspector as the appointed decision maker for the appeal, but it's plainly reasonable for the inspector to make his decision on the basis that he should approach the decision in the way that the local authority, his qualifying authority, has undertaken to do. Note also paragraph 10.1.1. This is actually something that is an obligation of the nominated undertaker, but it takes us back to an earlier section in this document. The nominated undertaker shall submit requests for approval of construction arrangements, plans and specifications and mitigation schemes in compliance with the guidelines on standardised pro forma to be drawn up by the forum. And that takes us back to section 4.
This isn't a construction arrangement, though, is it?
This is to do with...
these are approval for roads.
That's absolutely correct. Yes, it doesn't directly apply to this. That's a false point. Let me go back. The point I wanted to make was at page 180. Which is in relation to the role of the planning forum.
Sorry,
Page 180.
180, sorry.
Section 4 of the planning memorandum. At 4.1.1, one sees that the role of the qualifying authorities join with other qualifying authorities and the nominated undertaker, together with departmental representatives, in establishing a planning forum to help coordinate and secure the expeditious implementation of the planning provisions of the bill. So there's my point about the quid pro quo. Signing the memorandum gives rise to membership of the forum, paragraph 4.1.2. And 4.1.3, the forum will meet regularly to help coordinate and secure the expeditious implementation of these planning provisions. Will prepare planning forum notes on related matters. Will set out standards and practices to be followed by those implementing the planning edition schedule. And at 4.1.5, just carrying on with this theme, in considering the request for approval, qualifying authorities will have regard to the planning condition schedule contained in the bill, the conclusions of the forum, and the planning forum notes. And the nominated undertaker 4.1.6 will do the same. So that document that you were shown earlier, the planning forum note 6, which was the which set the benchmark, if you will, for the written statement and the RONIS that was submitted by the interested party in support of the application for approval. Though that was a document which was the product of this part of the qualifying authority's role and undertaking. And you'll see at the bottom of that document that it was approved. It was agreed as final at a meeting of the planning forum on the 2nd of November 2017, so some 6 months after royal assent to the Act. And Hillingdon were part of that agreement, therefore they're part of the planning forum. And it was surprising in a way, earlier on today, that Mr. Hal Williams appeared to be so dismissive of that process, and almost suggested that the planning forum note involved a box ticking exercise, but that actually Hillingdon had essentially carte blanche to impose whatever requirements as to information and so forth that it saw fit. That is contrary to the constitutional arrangements which arise under paragraph 13 of Schedule 17 to this Act. Hillingdon have secured these wider powers of control on the basis of undertaking that they will receive and consider and determine applications on the basis of the information that is provided in accordance with the planning forum notes and the template submissions.
So this is all about lorry route approvals, and we're actually talking about lorry arrangements re the use of the routes, and there's no separate note for the arrangements for the use of the road.
Yes, but the lorry route approvals that are mentioned, that are dealt with in this note,
Yeah.
that is a shorthand for the subject matter of paragraph 6 of Schedule 17.
Everything.
Yes, it does. Paragraph 6 uses the phrase the word arrangements, if you remember.
Right.
But
You approve the roads, and then they've got to be conducted in accordance with the arrangements with respect to the roads, which is what I've taken to be the legal hook on which you say they don't just have to approve the roads, they could actually say restrictions on a particular road
Yes.
on particular times.
But this note, planning forum note 6, that you have in front of you, I accept it's headed lorry route approvals, but the information that the planning forum agreed should be provided in support of such an application is intended to enable the given local qualifying authority who's faced with making a decision about an application for approval under paragraph 6 to provide them with the information that they are expected to require.
So the only thing they
in order
approve
to
is the
make that
routes.
decision.
The only thing they approve is the routes. The use of the routes has got to be in accordance with the arrangements approved by the authority. So no, they've got to approve the arrangements, not the routes.
No,
Not only the routes.
There is a, in a sense, what your lordship has, I think, well, my submission is what your lordship has alighted upon, is the fact that the paragraph 6 is, if you like, known as in the trade as a paragraph that requires approval of lorry routes. But actually, the statutory language, as your lordship points out, relates to arrangements. subparagraph 2 of paragraph 6 does say the matters to which this paragraph applies are the routes by which anything is to be
But
transported.
one says that development must, with respect to the matters to which this paragraph applies, be carried out in accordance with arrangements. You could put the two together and say development must, with respect to the routes by which anything is to be transported on a highway, be carried out in accordance with the arrangements approved. It is the arrangements, actually, that have to be approved looking at it.
Yes, but what is clear, it didn't arise in this case, is that it is open to an authority in an appropriate case to say, we don't like this selected route. We require you to modify your routing arrangements to run your lorries down this alternative route.
The arrangements must include the route as well as the hours of operation.
Exactly.
you're saying.
Yeah.
Well, it would include the access, wouldn't it?
Yes.
The access, the route, and the hours.
Yes. The language, the word arrangement is obviously a somewhat open-ended choice of words, but it's not been suggested, I think, by any party in these proceedings that it is not wide enough to include each of those three matters. So it can include the routes themselves, it can include controls on timing of movements, and it can include modifications to access arrangements.
The reason why I disappeared down this rabbit hole was that all you need for approval is a list of roads and a required for suppliers. And then the other information is the thing that includes the numbers and timings and sites. And it seems to me there would have to be something else for approval of those. There's no other document than the one we've got.
No. My reading of it has been that the list of roads, clearly the fundamental requirement on any application under paragraph 6 will be for endorsement of the roads that are set out in the application itself. But that in order to enable qualifying authority to make a judgment in the given case as to whether it should look for any further modifications, any modifications less than requiring an alternative route. Information is required to cover the points that are set out under the heading for information.
I don't know whether it helps you or doesn't help you, but if you say, well, in working out what the task is and whether there's adequate information for that task, does this document indicate that in fact, although you'll have information, you're not expected to be approving numbers and timings, although it's possible that the information that arises may show problems over numbers and timings, or whether it's neutral on that?
Well, that I suspect is what was intended, in the sense that the information, the third Roman 3 in the box, a written statement. A written statement, it says, which 3 provides a summary of the lorry route information for the local traffic management plan, which will include predicted LDV numbers and timing. That certainly implies that in the ordinary course of events, detailed controls on the movement of traffic is something that will be found in the local traffic management plan, rather than being the subject matter of specific controls imposed.
Because otherwise you'd be for approval, a list of roads and requiring to use the most appropriate roads and a statement of the times at which the thing will be operated.
Yeah.
Doesn't mean they can't control it, but it might suggest that's not the focus. I don't know, I'm just asking.
Well,
you're the one who produced it.
I think it was the forum actually, but anyway, I'm probably a better place to speak to it. Anyway, my understanding is, well, the local traffic management plan, I can show you the code of construction practice again in a moment. The local traffic management plan is clearly intended that should take on the role ordinarily of managing timing of deliveries and managing safety of worksite accesses and so forth. Those are matters that are specified in Chapter 14 of the Code of Construction Practice. We'll come back to that in a second. But my point, which is intended to be helpful, in a sense, to Hillingdon, my point is that it doesn't follow from that local authorities are unable, with their jurisdiction, if you like, under paragraph 6, to consider whether, notwithstanding the existence of those controls under local traffic management plans, whether additional specific controls are merited in the circumstances of a given road or a given set of roads.
But that conditions the exercise and therefore the information.
Yes, and from the submission that I seek to emphasise before this court in response to this challenge is that however you take that, whatever the interrelationship between paragraph 6 of Schedule 17 and the local traffic management plan, indeed the route-wide traffic management plan, but the local one is perhaps the one which one should focus for today's purpose. However you see that relationship, it is clear that the contents of the local traffic management plan are both capable of being material to a decision whether conditions are necessary to control matters like timing of vehicles and so forth. And that the judgment as to whether they are material and what weight should be given to those traffic management measures in the local traffic management plan is first and foremost for the decision maker. And the first instance decision maker under the planning schedule, i.e. the local authority, may come to a very different view about that to the appellate decision maker if there is an appeal which is focused on that issue. And none of those matters involves any issue of law beyond standard Wednesbury review. Each of those is essentially a question for judgment and is completely within conventional principles of public law as it applies to planning decision making. And I say that is essentially the exercise that the inspector was engaged upon in his detailed analysis of the case for condition 1 and or condition 2 in the present case. And my purpose in referring to paragraph 4 was simply to show that the Hillingdon, as a qualifying authority, are themselves committed in order to exercise the powers and, if you will, to make that judgment for themselves in relation to any application that's put to, any approval applications put to them. Paragraph 6. They are committed to approaching matters with the planning forum notes well in mind, and also, of course, as we've seen with the other undertakings to which I've drawn your attention, with the statutory guidance and with the Code of Construction Practice and its constituent traffic plans well in mind. So can I just take you back to the code, conscious of the time?
Yes, let's just take stock. It's 3:45 nearly.
Yes. Well, I've largely covered the points that I wanted to take. I've perhaps another 5 or 10 minutes, and then I'll stop. And then
that will give you enough time, Mr. Elvin, I hope. Will that give you enough time to make you? It's going to have to.
I mean, Mr. Bold and I have, as you might imagine, discussed how we were going to apportion this. So I'm hopeful if the court's willing to allow me about 20 minutes.
Yes. Yeah. And then reply. But we have to finish today, as all of you know.
So the code is at tab 9 in the supplementary bundle. For your note, I don't think you were shown this earlier. Can you please just note section 4 at page 164, paragraphs, and section 4.1, which deals with the question of enforcement, because there should be no misunderstanding about the fact that this is the requirements of this document must be complied with in the construction of HS2. In the traffic and transport section, local area measures and local traffic management plans are dealt with at 14.2.4 on page 169 through to 14.2.6 on 170, and you will also have noticed traffic and transport management site-specific measures on page 171 and monitoring at 14.4 on 173. So can I just ask you to have those passages in mind, and note on page 170 where certain items are identified as being included in local traffic management plans. And at 14.2.5, you see in relation to lorry management, LTMPs will include details of the following are appropriate: timing of site operations and timing of traffic movements, local routes to be used by lorries generated for construction activity, etc. These are documents that are prepared, as you know, in consultation with the local highway authorities. Monitoring arrangements are also prepared in consultation with local highway authorities. See page 173. And the route-wide traffic management plan will include monitoring arrangements and lorry route signing strategy. See page 168, 169. And I think Mr. Elvin's going to draw your attention briefly to the vehicle management system, which was something that the inspector attached significance to in the present case. So, in a nutshell, that's what local traffic management plans are to include, and in the written statement that was submitted in support of this application, as foreshadowed by the planning forum arrangements, the nominated undertaker drew attention to the local traffic management plan for Hillingdon, see page 54, and covered, amongst other things, its intended contents, the role of the traffic liaison group. It was a consultative, it was a document on which there was local consultation, and the fact that it's a living document, so it's able to respond to changing needs, changing impacts, in order to make sure that as difficulties and changes arise, they can be addressed. And then the estimated LGV numbers and timings are set out on the following pages 55 and 56, in accordance with the planning forum note, and you can see that they are themselves derived from the local traffic management plan. These are not assumed numbers, they're predicted numbers. That's the word used in 2174 on page 55.
Yeah.
My Lord Justice Lewis raised in argument with Mr. Hal Williams what the inspector says in his decision at paragraphs 62 and 63 on page 266 in the full bundle. Those two paragraphs are plainly his own judgment as to whether evidence relied upon by the council in support of a condition relating to peak hours supported the council's case. The references are firstly section 3.1.1 in Hillingdon's statement of case, which you will find at in the supplementary bundle at
tab 11, I think.
198. Sorry, I'm so sorry, I've given you the wrong reference. It's 4.1.1 on page 207, not 3.1. 4.1.1 on page 207. At the beginning of the council's case in relation to conditions, where they carry out an analysis of the predicted vehicle movements, and that analysis was addressed and corrected by HS2 at paragraphs 4.7 to 4.10 in their written response, which is at supplementary bundle page 283. And that is the evidence on which the inspector drew in paragraphs 62 and 63 of his decision. So that is indeed his evaluation of the asserted evidential case for peak time controls on the basis that the peak time numbers would be elevated to a degree that merited some special control. He said that he accepted HS2 Ltd's evidence that that asserted basis on the part of the council was based on a misunderstanding of the figures. That again is classic planning judgment. And it is his own evaluation. He's not abrogating that. He's not relying on a burden of proof. He's not imposing a standard of proof. He's saying the council's case doesn't stack up. And that was a matter for him. So there are essentially two grounds for rejecting the case for condition 1. One is that the council's case on the evidence for that condition doesn't stack up. There isn't an evidence case for additional peak time controls. Secondly, the Code of Construction Practice and the traffic management plans will provide the necessary management measures, and it's not necessary to add to them on the evidence in this case. In relation to proposed condition 2, he said that whereas in an earlier case there had clearly been a site-specific and clearly evidenced justification for safety measures in particular access, which had been accepted by the Secretary of State, in this case the council's case was generalised, and for that reason didn't stack up. But again, he identified the traffic management plans in the Code of Construction Practice as providing arrangements for safe operation of accesses and the free flow of traffic, and following statutory guidance and giving effect to Hillingdon's undertakings as qualifying authority, he attached material weight to those factors. And as this case was on analysis, really in practice, about whether conditions were justified, inspector dealt with that question. He dealt with it on the basis of his own judgment. And paragraph 94, where he says, for the reasons set out, I find that the council has not provided clear evidence, etc. He means what he says. He has made that judgment. He has made that finding. And the fact that he has used language which now he wouldn't use is not material to the validity of his decision. And that was Mr. Justice Ouseley's judgment. I simply seek to add my own submissions as to why he was right to make that judgment. And my Lord, if it's necessary to resort to section 31, 3C, because you're less sanguine than Mr. Justice Ouseley about the lack of materiality of those, the way in which the inspector expressed himself, for the same reasons, it is plain that the inspector was highly likely to have come, at least highly likely to have come to the same view as to whether either of those two conditions was necessary. I say nothing about grounds 2 and 3 beyond what I've said in my statement argument. They are essentially another way of saying that. And I'm sorry to have gone on till 5 to 4, but unless I can assist you further, those are my submissions.
No, thank you very much, Mr. March. Thank you. Yes, Mr. Eldon.
Lord, can I reinforce the point? Of course, I adopt everything that Mr. Mould has said, including, if necessary, the reliance on Section 31 of the Senior Courts Act.
Yeah.
Can I reinforce the point about this being a single project, the point about this being a development from the Planning Commission? If I can, and I'm afraid that there's no authority, but it's established well enough, no authority before the court, that is. This is a single project for environmental impact assessment purposes. The court is aware of the fact that this was subject to environmental assessment, and it was, there were additional environmental statements provided as the scheme developed. Environmental assessment, as the court will know, is required for a project. The project is HS2, not part of HS2, and the court will also be aware of the views of the European Court of Justice, a project division such as the Commission against Spain, where the road system around Madrid was divided into multiple schemes to avoid EIA. Of course, the routes are part of this project which has already been assessed. It is no use, my learned friend, submitting this needed a bespoke assessment. This had, as a matter of law, to be assessed in order for the grant of planning permission to be issued pursuant to statute. It is not something for a bespoke assessment. It is merely a development of what has already been assessed and accepted by Parliament with the various undertakings and assurances. The constitutional setup, so to speak, is that of Parliament approving the scheme subject to those environmental, the environmental information and the assurances and undertakings that form part of the overall acceptance by Parliament that this was the appropriate way forward. And that, of course, sits side by side with the constitutional framework for this procedure being tied in with the undertakings given by Hillingdon to be made a qualifying authority, and I don't need to go into that because the learned friend has already dealt with that. I just remind the court, my Lord the Senior President, paragraphs 14 to 18 of the judgment in Hillingdon 1 deal with the relevance of those factors, though doesn't give the date.
Right.
So in my respectful submission, this is part and parcel. It is a subsidiary aspect of it, a project which has been already assessed. And indeed, the undertaking, the undertakings which my learned friend directed the court to, of which there are many that affect this aspect of the project, are in the ROMIS, tab, supplementary bundle, tab 5, pages 81 to 98, which the key one is the 550 on page 87. that is all part and parcel of the entire project. And Hillingdon can't have one without accepting the other. It is a qualifying authority, therefore it must accept, as it has agreed, the undertakings it has given. It is the beneficiary of the undertakings set out in the Romis because it is part of the project which has been approved by Parliament. My second point, in support of Mr. Mould and Mr. Mould's and HS2's case, is, as I indicated in an intervention before lunch, Hillingdon has not fully accurately characterised its case to the inspector. Hillingdon's case may have been that there was a lack of information that it would have liked in order, it says, to discharge its duty. But it went to the inspector on the clear basis that there was evidence that justified the imposition of those conditions. This will appear in our additions to the note in due course, but can I just give the court the references? The minutes of the relevant committee, tab 13 of the supplementary bundle, page 227, uses the phrase clear evidence. The reasons for refusal, first sentence of number 1, tab 1 of the supplementary bundle, page 2, has evidence, is the phrase. By the time the council came to serve its statement of case, paragraph 3.1.2, which is tab 11, apologies, page 198, clear and undeniable evidence was the phrase, which therefore leads one to understand quite easily why the inspector approached the matter from in paragraphs 29 and 36 of his decision, pages 260 and 261 of the core bundle, from the point of view of saying the council's reliance is upon the evidence that HS2 has adduced to make its case, which turns on its head, effectively, the learned friend's case to say there was no evidence. The council was relying on the information it had, including the wider information, such as the TfL report on the roundabout. On the issue of paragraph 6 and the ought to, the simple answer to that, in my respectful submission, is it brings in a planning judgment on the part of the qualifying authority or the appellate decision maker, if it's appealed, to decide whether the situation is such that it ought to modify. That is to say, a judgment has to be reached as to whether the evidence is such that there is sufficient prejudicial, etc. effect, in this case under 5b2, prejudicial effects on road safety or free flow of traffic, which justified the imposition of modifications. Not any prejudice, but prejudice which ought to lead to modification. There is inherent in that a judgment for the decision maker. And that, in my respectful submission, is the end of the matter. It is not, it doesn't set a standard, it sets a judgment for the decision maker. A judgment which can be argued on appeal on the basis of evidence.
And that's part of the, when the inspector said in paragraph 34, demonstrate that the proposed arrangement will be so prejudicial as to require that the submission to be modified, you say that was entirely consistent with that.
He's asking the question, is there evidence of prejudice such that I ought to support a modification?
Yeah. He does use the phrase burden of proof.
He does, but I don't depart from what Mr. Mould has said. It's familiar, as the learned judge did below, to remind oneself of how planning conditions are dealt with. At a planning inquiry, an appeal of this nature, if it were a planning appeal, the parties seeking to impose conditions, whether they're third parties or the local planning authority, have to justify their case. And they have to demonstrate certain requirements to be met before they can justify the imposition. It's no more than that. And if it is ill-chosen phraseology, it makes no difference in substance, and I don't differ from the way Mr. Mould puts the case. The next point I want to draw the court's attention to is the fact that there was evidence, and these were not just wet finger in the air guesses at traffic, but they were genuine estimates. Now, before a project is underway, of course, you can only come up with estimates of traffic generation. You can't have actual figures because they don't exist. And can I take the court back, please, to the better copy of Supplementary Bundle Tab 4, the Schedule 17 statement, which you have in the separate file that I handed up before.
Let's look at the separate file.
Yes, it's the legible colour file.
Yeah.
If I could ask you to go to page 55. This is the page I referred to earlier, estimated LGV numbers and timings. You've got timings in terms of the working hours. You then have the movements for each of the compounds. And you get South Ruislip, West Ruislip, Breakspear Road, and then Northeld Tunnel and Harville Road realignment. And the numbers that you see come from these. These are the numbers that were provided. So you've got a breakdown site by site of traffic generation. You're given the average and then the maximum. If you want to know where the 480 comes from, it's an addition of all of the sites, excluding South Ruislip. South Ruislip is excluded because it has an entirely different route. If you go back to page 38 of this document, you'll see the South Ruislip vent shaft has a route which doesn't take it via Harville Road and Swakeley's Road and Swakeley's Roundabout, and that can be compared, for example, with page 40, the West Ruislip Portal satellite compound, and you can see its interaction with Swakeley's Road, the roundabout, etc. And the same is true of the other four sites. So the 480 are the numbers affecting the Swakeley's roundabout. So that's why you get 480, not 550, which is the larger figure. You also have, just for completeness, page 49, an explanation of the routes and why alternatives were rejected. You also then have, page 56, the ROMIS referred to.
Sorry, the previous reference was?
Sorry, just to the choice of the routes.
No, the page. I'm sorry, the page.
Sorry?
The page
49.
number.
Yes.
49.
Yes, that's the route selection reasons,
Yeah.
and why the alternative was rejected. Was not disputed. You then have on 56 the ROMIS referred to. 57 the lorry routes for approval, because the list of roads has to be submitted under the planning forum note, and that was done. The ROMIS, the court has already seen, and the undertakings. The steps that were taken, the steps that were required, Mr. Mould has already taken the court to 3.2 and 3.5, supplementary bundle, tab 5, pages 73 and 75. There were not.
You're going, for me, you're going just slightly too fast. I'm sorry, because I'm writing and listening and not quite keeping up. I'm sorry.
I'm just conscious of the time.
No, of course you are. But just the last two references.
Yeah, pages 73 and 75 of the supplementary bundle.
Yeah.
Tab 5. These are the tables in the ROMIS as to the proposed measures that needed to be taken for the routes and the access. And you'll see that there were a number of measures for the roads, including junction layout being improved and visibilities and the like being dealt with. Site access, there were no issues seen to arise, and therefore no measures were suggested. So there are site-specific details as to measures to be taken as well. The traffic management plan, which is tab 20 of the supplementary bundle. As Mr. Mould has said, and it's acknowledged in the Council's report, the officer's report, this is a living document. It's a matter for constant discussion between the authorities, HS2 and Transport for London. This is the latest version. The version in front of the inspector was version 3, but the structure is the same. the court, if the court goes to page 320, please, you'll see the scope of the LTMP is set out, particularly at 2.14, 2.15. What is not included in the bundle is there is a site-by-site breakdown of the various measures that have to be taken. I don't think the court needs to see that. And impact on bus services, routes, social impact, cycle routes and the like, temporary works, and then one gets to page 323, managing construction movements, which is section 6. And there you have, and this is December 2020, you then have the updated site and flow forecasts, and you will see at the foot of 325, 550. And you'll see above it the forecasts for each of the various compounds in the locality. You then have at 6.4 and 6.5 site capacities, local measures, proposed working hours. And then finally on 327, you have inserted what was promised to the inspector, the VMS requirements. And that is to say, it has been implemented. These work sites are now in operation, and the court will have spotted that one of them is the portal, and the tunnel boring machine has already been launched and is somewhere under the Chilterns. But the VMS has been implemented. You'll see it's 6.6.3. You will see there's a limitation of 275 vehicles or 550 movements. The AM, PM peaks are the ones that Hillingdon wanted, and there are restrictions for the peaks, percentage restrictions as to the numbers. So you'll see that they're set out also at 6.6.4. So the mechanism which the inspector said he was satisfied he didn't need to duplicate, the court can see in operation, limiting the numbers, the total numbers, limiting the peak period flows, and the details as to how the VMS works. It was considered in the officer's report.
Was this agreed after the inspector's decision then?
Yes, the inspector had version 3, but this was anticipated. I hesitate to raise
Don't
this
worry,
document, but
you can see that you were saying from the documents we've
Yes.
seen about how you calculated the percentage of on and off movements, and
Yes.
this is now in writ form in this new agreement.
indeed,
that comes
and that's
later.
merely showing the system in operation. It's an iterative process as the scheme goes on.
It looks as the figures agreed are the ones that he was working from your statement.
Indeed.
As far as I can tell.
Indeed, they're consistent. Now, we haven't put this into the court. This is the route-wide traffic management plan, which you'll have seen. I can see my Lord Justice Lewis looking enthused at the idea of a lengthy document. I'm not. We have copies if the court wants to take it away. All I wish to point out is that Chapter 4 sets out issues about flow management, including details.
I'm awfully sorry.
It's evidence that you have, Mr.
Just listen, Mr. Elton, please. Before you respond to the objection I'm about to make,
Yes.
I'm about to object. We haven't objected to the reduction of the current LTMP, which, as Lord Justice Lewis has already pointed out, was not before the inspector. It has no relevance to the inspector's decision. All it and the bench, I'm sure, will appreciate when I tell you, this was produced during the currency of the High Court proceeding. But I do object to the production of evidence which I haven't had the opportunity to see. And much as I trust Mr. Elvin on many things, I'd obviously like to have any opportunity to respond to what he's about to say on it. I'm not going to get that.
All right. Well, no, I think Mr. Elwin will not receive that document.
No, I'm not asking you
No,
to receive it.
I'm content that we should proceed without the document. I think my colleagues are too.
I'm not proposing to. The only point I wish to make, it's referred to in some length in the officer's report. It's referred to in the inspector's report as well. It was before the local authority, and they refer to it on numerous occasions, and this is the version that was available to them. Although it is generic advice, it is not general, is the only point I'm going to make. It contains a whole series of specific measures which are brought in and you see reflected in the LTMP. And yes, of course, I've already made it clear this is a later statement than that before the inspector, but I merely draw attention to it as an indication of how the process works and why the inspector was right to say this will be dealt with in due course. And he makes it clear he did not have VMS position before him at the time, but it was before the learned judge.
Right.
I do find it slightly peculiar that the council objects to seeing evidence that they had before them at the time, but there it is. That's all I wish to say about the RMTP and the LTMP. But the important point is that the information was there, the mechanisms were there, and the mechanisms can be seen to be working. What this is about is Hillingdon wanting more information than is or was necessary. This is not about the adequacy of the information of Hillingdon wanting some more. I'm not going to speculate on motives, but the fact is Hillingdon had these various documents, and where they're referenced in the officer's report, that will appear in the note, which is not agreed, but we'll add our own comments to it in a different colour, and the court will have those references. The issue about the lack of baseline, I have two responses to that. One is the environmental statement provides the baseline, oddly enough. And secondly, the TfL study on Swakely's roundabout provided updated modelling for 2021 based on TfL's model for West London, called Wellham. And the court will have in the bundle the TfL report, the bundle I handed up, a better copy of the TfL report. I'm not going to spend a lot of time on this, but just to draw your attention to it, it's tab 14, but it's the second tab in my my bundle of 50 copies.
Tab 14.
Yeah. And I just draw the court's attention to the fact it's explained at pages 230 and 231. This is one of TfL's 5 highway assignment models, which models traffic for London. And you can see the areas that are modelled. It's London-wide on page 2. This is the West London model, Wellham, and you can see it's the purple area, which covers 5 boroughs: Brent, Ealing, Harrow, Hillingdon and Hounslow. So the baseline figures for 2021 were updated by the standard London highway model by TfL and appear here. And indeed, if the court would go briefly, and I'm nearly finished, tab 2 of the supplementary bundle. Pages 19 to 21, the council examines the TfL report, and although they've rejected the signalisation study because they hadn't understood it, for reasons the inspector deals with, they got the figures wrong. Can I just look at, ask you to look at the bottom of page 20, where the officer says the evidence in the Swakely's roundabout study fills a gap that HS2 has been reluctant to fill.
Sorry, you're reading from
the
page
foot
21.
The foot of page 20, last
Oh,
line.
20, sorry.
Yes. The passages start on page 19, but the relevant is point 1, foot of page 20.
Yeah.
And if the court looks at the conclusions to the TfL report, you'll see at page 35 a series of tables. Please don't ask me what overcapacity queues, PCU hours mean, or indeed link cruise time. But the important thing is it's information available to traffic engineers. Page 264 of tab 14, tables setting out the position in 2012, the new 2021 base, and then adding in the HS2 figures. And even with the fact that this was dealing with the 1460, not 550 movements, you'll see the comments at the bottom. Small increase in queues, travel times and fuel consumptions when compared with 2021 base case. Signalisation will reduce these adverse impacts, reducing travel times, etc. Signalisation will provide significant benefits. contrary to the officer's report, this report does not support the view that there are unassessed network impacts. This is a network-wide assessment. But in any event, that information, which was information relied upon in front of the inspector, gave base figures, revised base figures for 2021, and analysed, as you'll see, if you can bear dipping in further into the document, a whole series of plans which showed the impact on each of the parts of the highway. So my respectful submission, Lords, the case fails also on the basis of the fact that evidence was amply put forward to the inspector. It was available to and considered by Hillingdon. It actually deals with issues they say were not dealt with, such as the base figures. Fine, it did not emerge, it did not emanate specifically from HS2, but it was available and relied upon by Hillingdon. And the reason HS2 said that it was not something they relied upon, because HS2 was saying in their statement of case response, in the paragraphs referred to, that the figures, of course, it was dealing with 3 times the number of traffic movements than were actually going to be the situation here. It was dealing with the 1460 rather than the 550. Finally, and this is my last point, the point where the inspector rejected condition 1 on its own grounds, the percentage peak hour position. Sorry, I buried the inspector's report. This was the conclusion that he reached at paragraph 62. This is the reference to the uneven spread, and he says at 63, this is page 266, on this basis alone, proposed condition 1 does not satisfy. Yeah. And he refers to the response. I'm not asking the court to go to it. It's page 282 to 283 of the supplementary bundle, tab 16. And it explains that the council had confused movements with vehicles, and the percentage increase was based on vehicles. But my final point is, what Malone and Friend hasn't taken you to is the fact that there had been discussions between council officers and the operator as to what the peak flows would be. If you go to tab 19 in the supplementary bundle, perhaps it was raised, in which case I apologise. But in any event, where it comes from, page 309 in tab 19, there's a confirmatory email from the council officer to Lucy Neal at SCS Railways, and you can see from that, although the council was saying we want even more information, there had been a discussion about important details that do not form part of the submission related to traffic numbers in the peak hours. That's where the percentages come from. So that was information provided to the council before it reached its decision.
Sorry, I'm just trying to find the place.
At 309.
Yeah, no, 309. Sorry.
Yes. Sorry, there's several emails in.
Yeah, no, I was looking at the wrong email. 309.
27th February.
Yeah, I've got that. And the party read.
And it's just below the heading 1 movement of LGVs and the peak hours and monitoring.
Yeah.
And that's where the percentages come from, which is then subject to the comment in our response statement of case, and that is the source of the point that the inspector makes for rejecting condition 1 on its own basis.
Right.
Lords, bearing in mind the time and the fact that the learned judge sets out matters in significant detail, and we take no issue with the way he's put matters, unless I can assist the court any further, I've no further questions.
Okay. Right, thank you very much, Mr. Owen. Yes, Mr. Hall-Williams.
Thank you, my lord. I don't have much by way of response. I can't guarantee to finish before 4:30, but shortly after, if court would allow that.
Yes, that's fine. Yeah, but I'm sorry, I was being discourteous to my colleagues. I should have asked them whether it was all right to go on after 4:30. I've now done so.
No meetings this evening.
They very graciously
Enjoy
said it.
luck.
Very graciously said it is.
Just some very short responses to Mr. Mole's submission. You recall he started off by drawing to the court's attention the undertakings and placing some weight upon the undertakings by the qualifying authority, here being the London Borough of Hillingdon. But the short response to that is the qualifying authority's signature to the memorandum, which is in the bundle, and perfectly in alignment with the Court of Appeal's decision. But that submission doesn't address the question whether or not the inspector has erred in law. And in particular, whether or not the inspector has done what the Court of Appeal said should not be done, which is to hive off matters for Schedule 17 to a separate process operated by HS2. Qualifying authorities signed up on the basis that Schedule 17 was in place, cognizant and relying on the ability to evaluate impacts so as to seek proper controls on the important matters set out in the schedule. The second related point, when Mr. Mould was referring to the planning memorandum and in discussion with your lordships, there was a quiet suggestion that the matters to be dealt with under Schedule 17 were in some way not that significant, not that important, might relate to subsidiary matters. Actually, they relate to fundamental matters. This is one of those cases. This is why the court should understand the council's concern. This relates to the opportunity for the authority given to it by Parliament to evaluate impacts, to see whether controls should be put in place to mitigate those impacts. And there was even a suggestion at one stage that roads weren't part of the Schedule 17 approval. That's indeed covered by the inspector in the decision letter. Roads are covered. And it's not a simple matter of traffic management measures that are referred to loosely in the EMRs, subject to whether or not HS2 feels it reasonably practicable to put in place. The whole purpose of Schedule 17 is for an evaluation to be carried out by the qualifying authority to determine whether measures and mitigation should be put in place at this stage.
Or whether the arrangements ought to be modified more accurately.
That's quite correct.
Yeah.
But the modification is there in order to reduce or prevent prejudicial effects. I'm using the word mitigation for short, but the proposals, whether they ought to be modified. There was also an implicit suggestion or criticism about delay, a matter that my Lord referred to in the order before the court. Of course, it was open to the Secretaries of State and indeed Mr. Elvin, who indeed raised the point in his response to the permission, to inform the court that actually the consent is underway. There's been no delay in this case.
Yeah.
That hasn't been brought to your attention, and therefore it doesn't sit, if I may say so, happily to hear for those to suggest that there's some motive beyond that.
When you say the consent,
Schedule 17.
I'm so sorry, forgive me. When you say the consent is underway, Can you just unpack that a little for us? What does that mean exactly?
Well, as I understand it, the lorry route arrangements are taking place. They're currently, HS2 are currently implementing the scheme as approved. And if I'm wrong on that, I'm sure I'll be corrected. But I expressly took instructions on that because of the question that was raised in the permission order.
Well, does that mean that these proceedings are strictly academic?
No, it doesn't.
I mean, on their own facts and circumstances?
No, it doesn't, my Lord, no.
Because they've started, but they haven't finished.
Oh, that's quite far from it.
Yeah.
So it's not academic.
And indeed, at the
If
moment,
we quashed
Right,
it,
so
it's really no.
there's still a point in the proceedings because the works are continuing. Yeah. And when are they due to be completed, these works?
I think that's an unknown quantity. The original period for 5 years, but for a number of reasons, there's no certainty on that, and the peak period has not been reached.
I'm told about 2025.
Oh, I see. So the arrangements are in place for that length of time. Yeah. Right. So what we can record is the lorry route arrangements are all taking place. Is that right?
I'm afraid I don't know the answer.
I'll take instructions. We'll relay back to the team for.
Well, if that's something that you would all really rather deal with by way of a short email after the hearing, dealing only with that matter, then that's fine.
Probably something you would agree.
I hope we'll be able to agree that. We will do that. To make sure that we've given the court.
Yeah, that would help us just to get the facts clear. Thank you.
Mr. Mould took the Court of Appeal judgment in Hillingdon 1 and made some submissions, in particular about paragraph 70, and was stressing the point that adequacy should be regarded in the context of rationality. But it needs to be emphasised here that it would, in my submission, cut across the rationale of the Court of Appeal's judgment if that was the way it was to be treated. The Court of Appeal was at pains to establish a system whereby the decision-making stage in Schedule 17 should not be circumvented. If it was to remain open without the duty stage, deposit stage, to which the Court of Appeal put in place, if it was open to HS2 to provide information which wasn't adequate, and there was no such opportunity for the authority not to decline to process it, the matter would go to the Secretary of State, and the authority's responsible job under paragraph 6 given to it by Parliament would have been circumvented. That is exactly what the Court of Appeal was seeking to avoid. And paragraph 68 is of particular importance in that regard.
Paragraph 68.
68, Lord. Indeed, it's noticeable in the judgment that there's no direct reference to this paragraph in the learned Church's judgment in his conclusions section. His judgment doesn't grapple with the reasoning in this paragraph in our submission. It needs to be emphasised, there are two things in respect of this point, that the scheme understood by the Court of Appeal, requires the parties to collaborate to ensure, by way of a balance of the competing interests here, that local planning authorities retain the decision-making responsibility. That balance is referred to in paragraph 80 of the Court of Appeal's judgment. Responsibility and accountability has been given by them. The learned judge hasn't dealt with this point, and what we said about how the parties are expected to work together. That's what I mean by a bespoke scheme. Second point to emphasise is that the statute imposed statutory duties to ensure Parliament's intention was fulfilled, so that if HS2 supply insufficient information to allow an evaluative decision to be taken and can then appeal, the effect would be to pass over the decision to the Secretary of State and deprive authorities of exactly what Parliament had intended to give it for its control. In our respectful submission, the Court of Appeal paid proper attention to the procedural correctness of its decision. In particular, paragraphs 68 and 70. The Court of Appeal understood that a central tenet of Schedule 17 is that the authorities and HS2 should work together in advance of the deposit stage in a proportionate way to ensure that the authority could evaluate correctly. That was to avoid delay. That was part of the purpose. And that could be seen in particular paragraph 81, where the Court of Appeal said this: in striking this balance, it is hardly conceivable that Parliament intended to place evaluation of local interests into the hands of the nominated undertaker, HS2. This would have undermined the entire scheme. No admissible parliamentary material has been placed before us which would support such a view. Indeed, on our reading of the statutory guidance and the EMRs, it is assumed that HS2 will liaise closely with the planning authorities to enable the latter efficiently and expeditiously to perform the necessary evaluation of impact. The other point to emphasise, my lords, is this: the court did pay close attention, in particular to the procedural correctness of its decision, by reference to consultation. And that could be seen in paragraph 79, where there's express addressing of the need for the 8-week period for evaluation. And your lordships will, I'm sure, look at that. And so those are my submissions in relation to what Mr. Mould has submitted to you. And I turn just very briefly to deal with Mr. Eldon's submissions. And the first point he sought to make was an emphasis on the fact that the environmental statement had been based upon single project analysis. Again, actually that doesn't bear upon the issues before this court. Parliament did approve the Act, taking into account the environmental statement. It had to, under the directive. But it doesn't follow from that that the effects are necessarily and ultimately acceptable in circumstances where Parliament, in the Act itself, has provided a bespoke scheme for assessment of those very impacts in order to determine whether they should be reduced or in some way mitigated. And the last point I hope I can deal with by reference to a document. Mr. Elvin made a number of references to the evidence, and I don't return to the emails to which I did refer in my opening submissions, but I would ask your lordships to note that at paragraph tab 21, following the hearing in the High Court, HS2 put in a note with evidential references, and the court also allowed the council to put in a response to that note. And I hope your lordships will find it a helpful document, and it does respond to and rebut some of the points that Mr. Elwin has made, in particular from pages 336, 337 and 338. Just the last point I want to make is in response to Mr. Mould reference to section 31 of the Senior Corporate Act. I think it's our submission, probably pretty obvious, that the faults here are so fundamental that indeed it can't possibly be said that there would be any likelihood that there would be any different result. They go to the very root of the inspector's approach, and an approach which he himself set out in clear terms, and they go to the heart of the decision. Unless there's any further matter on which I can help you, that completes my submissions in response. Very grateful.
Thank you very much, Mr. Williams. Thank you. Thank you all very much for very clear submissions, both oral and in writing. We're very much obliged to you for the clarity and fullness of what you submitted. It will not surprise you to hear me say that we shall take time to consider our decision. Judgments will be provided in draft in due course for typographical and minor factual errors to be corrected, nothing of any greater substance than that. The parties should endeavour in the normal way to agree the terms of the order in draft and deal with any other matters by way of submissions made in advance of hand down. On the basis of those normal arrangements and subject to any intervening protocol, judgment will be handed down in due course, arrangements to be notified. There will be no need for attendance of counsel at hand down. Thank you.
Just, sorry, the note with our additions,
Yes.
If I send it through later today to your lordship's clerks?
Yes, if you would kindly, you can send it to all three clerks if you can manage that, but in any event to my clerk, Hannah Cullen. Please. Thank you all very much.